All right, welcome everyone. This is our question review for the real estate examination, for the PSI real estate examination, or Pearson, whichever one. And I'm excited to go through these. We're going to be going through these questions, and they're going to be reviewing different elements of really, really solid practice questions that will help you getting ready for this examination. Now, of course, we also have other products available for sale on our website. You can go check those out if you want, and you'll see demos of these in the YouTube channel as well. But if nothing else, this is going to help you significantly. So do these with us as we do them. Now, in the format, let's do this. Let me read the question. I'll give you guys a few seconds to think through it, and then we'll answer the question together. And I'll sort of give you my tidbits and tips as to why I think this answer is that way, or watch out for this deception or that deception or something like that. Okay, let's get into it. First question is, when considering a residential apartment complex, the duties of a blank include collecting rent from the tenants, general maintenance, overseeing repairs, and hiring outside contractors such as landscapers. So this is a pretty straightforward, what is this? Professional. Now, letter A is leasing agent. Letter B is independent contractor. Letter C is property manager. And letter D is leasing manager. I'll give you a few seconds. And the answer here is letter C, property manager. That's pretty straightforward. As far as it's a property manager handles collecting the rent checks, general maintenance, overseeing repairs, and hiring outside contractors such as landscapers. Independent contractor, not really. That's just, I would leave that out. It's really general or vague. They could be an independent contractor or not, but that has nothing to do with the question. Leasing agent would not be. If they were just leasing the property, then maybe. Or a leasing manager would be a similar kind of thing. So there you go. There is number one. All right, let's get into question number two. So Nathan schedules a listing appointment with an owner who is looking to sell their investment property. The seller tells Nathan that he wants to double the price he paid for the home 5 years ago, which was $200,000. And Nathan can keep anything over that amount as his commission. This type of listing would be, I'll give you a few seconds. All right, the answer is, this is a net listing. So this is a classic net listing style question. So remember, with net listings, the way that this is going to work is a net listing is where a seller is looking to net a specific dollar amount from the sale of the property, and anything that they can sell for above that number, the agent can keep. And this question is an exact scenario of a net listing. So remember what a net listing is. Now, something else that's important to note in this question. If you notice here, one of the answers, letter B, is a net lease. And this is classic for exam writers. Exam writers are going to throw the net lease in with the net listing and see if you pick it. Typically, they'll put net lease up higher and net listing will go down lower. That's typically what they did, and they did that here, B and D respectively. Remember and watch out for that. That's a classic trick. That's like our reticular activation system in our brain triggering, saying, oh, there's the answer. It's right in front of me. Or I missed it. It wasn't in front of me, and I picked the other one. So be very careful about that. That's classic test writing scenarios. I hope this one helps you out, because you're going to see something very similar to this, I'm pretty sure, on your actual examination. I'll see you in the next one. All right, let's do question number 3 here. A real estate agent is required to provide the Massachusetts mandatory real estate licensee consumer relationship disclosure, letter A, to every attendee at an open house, at the first personal meeting with the potential buyer to discuss a specific property, to a seller after they sign the listing agreement, or D, all of the above. I'll give you a few seconds. And the answer is letter B, at the first personal meeting with the potential buyer to discuss a specific property. Okay, so a couple things that we want to know about the Massachusetts mandatory licensee consumer relationship disclosure is definitely when we disclose it. So this is going to be a document that we disclose or give to the consumer at first personal meeting when they're inquiring about a specific property. Now, when they're inquiring about a specific property, they could play with you here. There's a lot of test wiggle. So in that, I mean, they could say a person calls up a real estate office and inquires about a specific property. Well, that's not their first personal meeting, so therefore we do not have to disclose that particular item. Now, The open house is classic. At every attendee at an open house, we do not have to use this disclosure form. And then to a seller after they sign the listing agreement, that's not the case. And then all of the above is absolutely not an answer. So the only possible answer here is at first personal meeting with a potential buyer to discuss a specific property. Okay. Let's get to number 4. Which of the following is not true about the 1988 amendments to the Fair Housing Act? Letter A, it adds familial status. Letter B, it added persons with physical disabilities. Letter C, it added sexual orientation. Letter D, it added persons with mental disabilities. I'll give you a few seconds to think about it. And the answer is letter C, it added sexual orientation. So which of the following is not true about the 1988 amendments to the Fair Housing Act? So we're looking for things that are not true. Therefore, all of the other ones should be true. So if you're looking at this question from that perspective, then the solution here would be say, well, what is true about the amendments to the Fair Housing Act of 1988? In 88, you would have learned in the courses that the familial status and disability, either physical or mental disability, were added in 1988, thus eliminating A, B, and D, giving us only sexual orientation as a potential. Now, check with your state, because your state fair housing laws might in fact cover sexual orientation. All right, let's check out question number 5. In Massachusetts, a real estate broker can practice dual agency if, letter A, the seller agrees to it in writing. Letter B, the buyer agrees to it in writing. Letter C, both A and B. Or letter D, dual agency is illegal in Massachusetts. I'll give you a few seconds. And the answer is letter C in this case. Both A and B. Number 1, to do dual agency, what we have to remember about dual agency is that both parties, this is where one agent is representing both sides and they're both clients. And in order to practice this, which is legal in Massachusetts, so that eliminates answer D, but both parties have to give assent in writing or permission in writing. So the short way here is we want to know that dual agency is allowed here in Massachusetts. So D is out, and then A and B, both parties have to give permission in writing in order to practice this, where one agent is representing both sides as clients. Okay, let's get into question number 6. The Consumer Protection Act, which protects consumers by prohibiting unfair or deceptive business practices, is, letter A, Mass General Law, Chapter 93A. Letter B, the Code of Regulations 254 CMR. Letter C, Mass General Law, Chapter 40B. Or letter D, Chapter 19A. And the answer is Mass General Law, Chapter 93A, letter A. All right, so for your exams, we definitely want to remember that MGL Chapter 93A equals the Consumer Protection Act. So anytime they reference the Consumer Protection Act, know that they're also talking about Mass General Law Chapter 93A. Now, the Code of Massachusetts Regulations, CMR, that's something that we don't really need to understand or know for these exams. So we do definitely need to know 93A. That is definitely on there. And let's jump to the next question. All right, question number 7. After the initial listing agreement between a seller and a broker has expired, the seller lists the property with a different broker. If the original listing broker then finds a buyer who wants to purchase the property, that broker, letter A, is a subagent. Letter B, must wait at least 90 days after the original listing expires. Letter C is unable to disclose any offers the seller received while was the listing broker for the property. And letter D is not able to disclose any information regarding the physical condition of the property. And the answer is letter C, is unable to disclose any offers the seller received while he was the listing broker for the property. Okay, this is definitely stuff you're going to see. They're long-winded interrogatories, long answers, okay? So that's very classic of state-style real estate examination questions. So you're going to see that. And you just need to sort. There's a couple of different things happening in that question. For example, they were talking about a previous listing agent and a new listing agent, and then they've referred to the previous listing agent. So you have to be very careful and tempoed as you're reading through these questions. So that's number one. Now, couple of other things here. A sub-agent wouldn't have been the answer because they're not really acting underneath, but in your courses, you would have learned what a sub-agent is. Must wait at least 90 days after the original listing. That has nothing to do with statutes, so that's just not it. That's not correct. Letter D is not able to disclose any information regarding the physical condition of the property. Well, that's the truth, but now if their roles have changed, if they're representing, let's say, a buyer, then they could disclose certain bits of information under certain situations if they were material in nature and could be defective about the property. Which gives us only letter C, is unable to disclose any offers that the seller received while he was the listing broker for the original property. All right, so that's number 7. Number 8, in regards to the Massachusetts home inspection law, a real estate salesperson must, letter A, recommend a reputable home inspection company and or inspector. Letter B, provide a home inspection report to the seller. Letter C, provide a home inspection report to the buyer. And letter D, provide a copy of the home inspector facts for consumers brochure to all buyer clients. I'll give you a few moments. And the answer is D, provide a copy of the home inspector's facts for the consumer brochure to all buyer clients. So this is straight out of the rules and regulations for real estate professionals here in the Commonwealth of Massachusetts. So this is something that you just need to know. And we need to know that when we're representing as a buyer's agents or buyer's agency, then the real estate professional must give a copy of this pamphlet, the facts for consumers, to all interested buyers in regards to what is a home inspection and how it can help and serve the buyer community. Okay? Providing a home inspection report to the seller was not an option. Providing a home inspection report to the buyer is, the home inspection report versus the brochure. So those two, letter B and C, are incorrect because it's saying that the agent is responsible for getting a home inspection performed on the property. And it is the consumer's responsibility to get a home inspection. They can absolutely waive that right. Recommend a reputable home inspection company and or inspector. And that isn't always the case to make a recommendation, although a buyer's agent can make a direct recommendation regarding a home inspector to a buyer. The go-to answer here is going to absolutely be letter D. In that case, that brochure needs to be given to every single consumer if they're interested in purchasing the property. All right, let's do number 9. If a home for sale was the site of a highly publicized murder/suicide, then the listing agent must disclose that fact. Letter A, in the property listing. Letter B, at first personal meeting with the potential buyer. Letter C, if they have knowledge of it and are asked about it directly. Or letter D, stigmatized properties never have to be disclosed in Massachusetts. I'll give you a second to think about it. And the answer is letter C, if you have direct knowledge of it in the real estate business and you are directly asked. So, psychologically impacted property conditions, also known as stigmatized properties here in the Commonwealth of Massachusetts, are absolutely fair game on real estate exams. They're very popular, and we need to remember what they are. Sites of murders, suicides, those types of things, scandalous events that have taken place on a property. We also want to know that here in Massachusetts, if we know the truth and we're directly asked about it, then we must answer truthfully. And if we're not asked about it, then stigmatized properties never have to be disclosed in Massachusetts. Letter D there might be a potential answer, but the go-to answer here is if you have knowledge of it and you're asked directly, you must answer. And that's when we disclose stigmatized issues like murders or suicides. All right, let's do number 10. If a salesperson is found to be in violation of the Massachusetts Fair Housing Law, Chapter 151B, they are subject to actions taken by the SJC in addition to the Board of Registration of Real Estate Brokers and Salespersons that must, letter A is suspend the license of the salesperson for 30 days. Letter B is suspend the license of a salesperson for 60 days. Letter C, suspend the license of a salesperson for 90 days. Letter D, immediately terminate the license of a salesperson with the possibility of reinstatement pending a board hearing. I'll give you a few seconds. And the answer is letter B, suspend the license of the salesperson for 60 days. All right, so these are solutions that you just need to know. By the way, SJC is Superior Judicial Court or Supreme Judicial Court, depending on the court of where this ultimately ends up. And, after appeal, of course, if there happens to be one. Mass General Law, Chapter 151B is the Massachusetts Fair Housing Act. So I would also remember those protected classes that you might have learned in your state modules. And you want to know that this is something you will see. The violation and the penalty is 60 days mandatory licensing suspension. There will be monetary penalties as well, but in this particular case, they're definitely just asking you, what about the licensing suspension? What is sort of the automatic? And the automatic is a 60-day license suspension at minimum for the license if found guilty of violating fair housing laws here in Massachusetts. This is a classic style question, and you just need to know the solutions here. So 60 days mandatory suspension for the initial infraction after they've been found guilty of violating fair housing laws here in the Commonwealth of Massachusetts. All right, here we go. Let's do question number 11. A lease in Massachusetts cannot require a tenant to pay a security deposit more than, letter A, 1 month's rent. Letter B, 3 months' rent. Letter C, 3 months' rent or $5,000, whichever is more. Letter D, 1 month's rent plus $500 per pet. All right, I'll give you a few seconds to think about it. A lease in Massachusetts cannot require a tenant to pay a security deposit more than, and the answer is 1 month's rent. All right. So 1 month's rent is, and what we're talking about here is we're talking about residential leasing. So for my friends that are going to be getting into the commercial real estate business, maybe you know this, maybe you don't, but anything is negotiable in commercial real estate. So the move-in fees can be significantly higher than 1 month's rent. That's not a big deal. Security deposits can exceed 1 month's rent. When we are taking examinations for real estate licenses, then we are considering only residential transactions unless otherwise stated. And they won't really go into landlord-tenant leasing issues with commercial issues. They're only going to do it for residential. So there's a big key right there for y'all to think about when you're taking any of these exams. Leave your commercial real estate hats at the testing center check-in and then think residential the entire rest of the time because that's what they're looking for. Now, 3 months rent, not acceptable. 3 months rent plus $5,000, whichever is more, not acceptable. So all of the other potential answers are not acceptable here. And just so you know, Massachusetts disallows any additional things like pet deposits and things of that nature. You can certainly charge more in rent, but you cannot charge a pet deposit in addition to anything. It has to be the equivalent of 1 month's rent, and 1 month's rent, no more. It can be less than 1 month's rent, but not exceed 1 month's rent. Alrighty, Rooney, let's do number 12. Number 12 is a real estate licensee in Massachusetts must complete how many hours of continuing education per renewal cycle? Is it letter A, 40 hours? Letter B, 60 hours. Letter C, 12 hours. Letter D, 24 hours. So the question is a real estate licensee in Massachusetts must complete how many hours of continuing education per renewal cycle? I'll give you a few seconds. Tick-tock, Mr. Wick. And the answer is, boom, 12 hours. Okay, so a couple things here. We definitely want to know 12 hours of continuing education for both real estate salespersons and real estate brokers. And the renewal cycle is every 2 years, and the license expires on your birthday. So we want to know those little bits. If we don't complete the continuing education, then our license will renew as inactive when we go to renew our license. If we do our continuing education and we pay our renewal fees, then we will be active. And then if we do nothing, then our license will simply expire. So here, the only other teaser here is 40 hours. 40 hours is the requirements for pre-licensing. So if the question was for pre-licensing versus continuing education, then you know that that's the answer. All right. All right, let's get into number 13. Question number 13. The pre-licensing requirements for a real estate broker candidate in Massachusetts includes letter A, 2 years of experience and 40 hours of pre-licensing course. Letter B, 2 years of experience and an 80-hour pre-licensing course. Letter C, 3 years of experience and an 80 hours pre-licensing course. Letter D, 3 years of experience and a 40-hour pre-licensing course. I'll give you a few seconds. And the answer is letter D, 3 years of experience and 40 hours of pre-licensing coursework. So remember, here in Massachusetts, in order to get your broker's license, we need to do a 3-year apprenticeship, a minimum of 25 hours a week for 3 years, affiliated with a real estate brokerage firm that's actively licensed, so an actively licensed salesperson for 3 years, and we need to do 3 years worth of that. Then we need to go to school again and do another 40 hours of pre-licensing education, pass an examination. We have to be bonded in the amount of $5,000. So these are all the requirements in order for us to get our broker's license, and we just want to be familiar with those and what it takes to become a salesperson, and that'll be helpful for the exam. Okay, so letter D here, 3 years of experience and a 40-hour pre-licensing course. All right, question number 14. Let's do it. The environmental laws and regulations that deal with septic systems in Massachusetts is letter A, Title V, letter B, Regulation Z, letter C, Chapter 40B, letter D, Mass General Law, Title 93A. Question again is the environmental laws and regulations that deal with septic systems here in the Commonwealth of Massachusetts is, I'll give you a few seconds. And the answer is Title V, letter A. Okay, so Title V is something we definitely want to know. And a couple of other little things here, like Regulation Z, that's the Truth in Lending Act. Chapter 40B has nothing to do with septic systems. That is something legitimate here in Massachusetts, but it's not really covered on the Massachusetts exam for the most part. For Mass General Law, Title 93A, Chapter 93A, not Title 93A. But 93A is the Consumer Protection Act. So we definitely want to know that. And with septic systems, we want to know a couple of little things about septics. Number one, Title V is what we call it. It's the Department of Environmental Protection's Section 5 or Title V of their code. It calls for the inspections of septic systems. Septic systems are on-site waste disposal systems here in we lack public sewer systems. We have on-site waste disposal systems, and that's what a septic system is. We want to make sure they're not leaking because they get contaminated groundwater and things of that nature. So they get inspected when the sale of an arm's length sale of a property happens, not during like a familial transfer or a trust situation or something like that. But when we're selling or expanding or renovating our properties and creating more waste, we need to get a Title V inspection. And we need to remember that there's a 6-month, we can delay it by 6 months if the ground is frozen, if there's no manhole cover, but we can get a Title V. We have to make sure that we're pumping it, and we have to make sure all of these things happen. You will absolutely need to know the points inside of your Massachusetts courses in order to remember when we need to get inspections and when we don't need inspections, and how that whole game works. All right, I'll talk to you about the next one coming up. All right, number 15. How long are real estate firms required to maintain their real estate records? Is it A, 1 year, B, 3 years, C, 7 years, or D, forever? Maintain those records forever. All right. How long are real estate firms required to maintain their real estate records? Is it A, 1 year, B, 3 years, C, 7 years, or D, forever? I'll give you a few seconds. And the answer is letter B, 3 years. So, books and records. That's something that you definitely will see on examinations potentially. Books and records, all books are maintained by the brokers. Brokers maintain all salespersons turn over records to their brokers or operation staff under the watchful eye of the broker. All records have to be maintained for 3 years here in the Commonwealth of Massachusetts, subject to audit. We want to make sure that all financial records, advertising, emails, those types of things, contracts, disclosures, all of those things need to be maintained for 3 years here, subject to audit in the Commonwealth of Massachusetts. So books and records are definitely something you want to know, and it's 3 years here in Massachusetts. All right, question number 16. Sellers of homes built before which year are required to provide a property transfer lead paint notification form? Letter A, 1974. Letter B, 1976. Letter C, 1978. And letter D, 1988. So again, sellers of homes built before which year are required to provide a property transfer lead paint notification form? I'll give you a few seconds. And the answer is all right, 1978. So here's a classic one of what we need to know about lead-based paint. Again, you want to make sure that we know bits and pieces about lead-based paint. In your course, we'll go over items about lead-based paint, but the big date is 1978. Properties built prior to 1978 have a high probability of containing lead, and we want to make sure that we know that particular date and connect 1978 with lead-based paint. All right, so we're definitely going to see that. 1988 is where we made the amendments to the Fair Housing Act. 76 really has nothing to do with us. And 74, that was the year that we passed the Equal Credit Opportunity Act. So there's some relevance to the dates, but they're irrelevant to this particular question. Question number 17. If a buyer with a child under the age of 6 discovers there is lead paint in the home that they are purchasing, how long do they have to de-lead the property? Letter A, 30 days. Letter B, 60 days. Letter C, 90 days. And letter D, it must be done prior to moving in. Once again, question number 17. If a buyer with a child under the age of 6 discovers there is lead paint in the home that they are purchasing, how long do they have to de-lead the property? I'll give you a few seconds. And the answer is 90 days. Okay, so lead-based paint is an important one potentially on Massachusetts examinations. The deal with lead is this. It's either hit or miss. There's a possibility that you're going to see a bunch of lead paint questions or no lead paint questions, depending on the version of the exam that you get. But we do want to study it as if you're going to get it. In my courses, I do cover lead-based paint, and I cover everything that you really need to know. The big thing with some dates is 1978, children younger than 6, and then when a buyer buys a home, then the home needs to be in lead-safe compliance within 90 days after taking ownership of that property. So you definitely want to know the 90-day thing. And again, it falls on the buyer's shoulders. You know, a buyer doesn't have to buy a property with lead, but a buyer needs to make it lead-safe if they buy the property with lead-based paint within 90 days if they have a child younger than 6 living at the property on a full-time basis. All right, so that was number 17. Number 18. Who appoints the designated members to the Board of Real Estate Brokers and Salespersons? Letter A, the Massachusetts Association of Realtors, MAR. Letter B, the Governor. Letter C, the Attorney General. Letter D, the National Association of Realtors, or NAR. Number 18, once again, who appoints the designated members to the Board of Real Estate Brokers and Salespersons? I'll give you a few seconds. And the answer is the governor. Okay, so when it comes down to the board, the governor appoints these particular parties to the board. It's a 5-member board, remember. 3 of the 5 members are brokers that have been practicing for a minimum of 7 years. The other 2 are just citizens of the Commonwealth of Massachusetts. All 5 are appointed to serve 5-year terms. And we definitely want to know a little bit about the board and their composition as a potential for the exam. All right, number 19. The Massachusetts Fair Housing Law poster must be visibly displayed, A, in all brokerage offices in Massachusetts, B, in all Massachusetts government offices, C, in all mass brokerage offices and all government offices here in Massachusetts, D, in all affordable housing complexes that are not handicap accessible. Once again, number 19, the Massachusetts Fair Housing Law poster must be visibly displayed, A, in all mass brokerage offices, B, in all mass government offices, C, in all mass brokerage offices and all mass government offices, or D, in all affordable housing complexes that are not handicap accessible. I'll give you a few seconds. And the answer is letter A, the Massachusetts Fair Housing Law poster must be visibly displayed in all mass brokerage offices. And we definitely want to know that. So we want to know the equal opportunity poster. We want to make sure that we understand what that kind of looks like. And we want to make sure that we know that that has to be posted in all mass brokerage offices. Otherwise, the responsibility of providing or proving that you didn't discriminate now falls on the shoulders of the brokerage firm. So that's an important one to note for the examination. And we want to make sure we're very, very straight with all of the Massachusetts real estate fair housing rules and regulations here in Massachusetts. Those will definitely serve you well. Number 20, a real estate advertisement in Massachusetts, including social media posts, must contain letter A, the real estate agent's name. Letter B, the real estate agent's license number. Letter C, the brokerage's name. Letter D, all of the above. Once again, number 20, a real estate advertisement in Massachusetts, including social media posts, must contain the following. Letter A, the real estate agent's name, the real estate agent's license number, the real estate brokerage's name, or D, all of the above. I'll give you a few seconds for that one. And the answer is letter C, the brokerage's name. And again, this is a classic. This type of question would be very, very, very classic on examinations because they just want you to know that the brokerage name is sufficient on an advertisement, including social media posts. We don't need the agent's name necessarily, and we don't need the agent's license number necessarily in the advertisement. It might be fine to put all of that extraneous information in there. That's fine, but the brokerage name must be identified inside of the advertisement. So this is classic, and this is what catches a lot of students on examinations. So look out for ones like this. And remember, a real estate advertisement in Massachusetts, including social media, must include the brokerage's name. If you're studying for your real estate exam right now, or if you're looking to level up your real estate knowledge, don't forget to like and subscribe.